Today's topic is going to be about contesting an estate plan and how can someone contest an estate plan and how we can prevent people from contesting estate plans. So there really is no way to block somebody from contesting an estate plan. In America, we can sue anybody anytime for pretty much anything. That's just how our judicial system is set up. So even with a no contest clause, as you'll sometimes hear that being referred to inside your will or your trust, even if we have a no contest clause that's built into your will or trust, it doesn't mean that we can prevent people from contesting your estate plan. They still have the right to contest your estate plan. The question is, will they win when they do contest it? And what the no contest clause does, it says, hey Johnny, if you're going to contest the estate plan after I'm gone, you better be certain you're going to win the contest. Otherwise, the no contest clause will say you're completely disinherited from receiving anything from the estate if you don't win the contest. But if Johnny does contest the estate plan and he gets the judge to agree that he had a legal right to contest the estate plan, and the judge agrees with Johnny's contest, then Johnny will get whatever the judge decides to award Johnny in that contested matter. Some ways that Johnny can contest the estate plan, and the burden of proof really is upon Johnny to bring these things forward, would be number one, when you signed your will or your trust, you didn't have capacity. You had dementia, you had Alzheimer's, there was something wrong with you, you didn't have the capacity to sign the document when you did. And so he can prove that by getting doctor's letters and going back and getting your medical records to prove that you were diagnosed with dementia or Alzheimer's prior to you signing your estate planning documents. So that's one way he could contest it. The second way he could contest it is he could prove that you were under duress. So if you came to your meeting with your estate planning attorney with your other son, Sam, and Sam was in the room when you signed your estate planning documents, and Sam was maybe the caretaker of mom and dad at the time when they signed the document, and they excluded Johnny from the estate plan, then Johnny could prove, well, Sam was in the room, Sam forced mom and dad to sign the document to cut me out, but for Sam forcing them to sign the document, making them do that, they never would have made that decision. You know, maybe Sam said, I'm not gonna feed you dinner tonight if you don't go in and see your estate planning attorney and cut out my brother Johnny. Or I'm not gonna take you to your dentist tomorrow if you don't go in and change your estate plan. And so Johnny can prove that they were under duress to sign their estate plan. Another way he could invalidate the estate plan and contest it is he could prove that they didn't understand what they were signing. They thought they were signing one thing, but they signed something else. So maybe they thought the estate plan was drafted to include Johnny, but really it was drafted to exclude him. And so they didn't know that that's what the estate plan actually said. Then he can contest it and invalidate the estate plan. So burden of proof would be upon the person that's contesting the estate plan. He can always contest it, but it's an uphill battle for him to do it. Certainly people say, well, is a will easier to contest than a trust? Yes, typically a trust can be harder to break than a will because a trust is put into place many years usually before death or incapacity occurs. And so when Johnny's in court saying, Your Honor, my parents didn't intend to create this document or they didn't draft it the way that they thought, you know, if they did this 10, 15 years ago and it's been an ongoing document that they've maintained for the last 10 to 15 years, putting assets into it, managing it, it's hard for him to prove that they didn't know what they were doing or wasn't drafted how they wanted because it was done so long ago and they've been operating it and using it for so many years. So a trust is usually a better vehicle to create if we're worried about a kid contesting it versus a will that you could sign the day before you die or a week before you die and it hasn't been operating and working for years in advance in that situation. So those are some ways to contest, and then ways that we can maybe mitigate contesting it, but always realize if your kids are going to contest the estate plan, they have the right to do that. And so just keep that in mind when you're excluding a child or decreasing their share from your estate plan. Hope that helps.